So, a very good morning to everyone. I, Vanshika and Pragati, first year students of Chemistry Honours, Hansraj College, would be the moderator of today's session. On behalf of the institution's Innovation Council, Hansraj College, I welcome you all to Impact Lecture Session 1 on Protect or Get Mugged Understanding Intellectual Property Rights. Institution's Innovation Council is an initiative of Ministry of Education, Government of India. Ministry of Education, Government of India has established MOE's Innovation Cell (MIC) to systematically foster the culture of innovation among all higher education institutions (HEIs). The primary mandate of MIC is to encourage, inspire, and nurture young students by supporting them to work with new ideas and transform them into prototypes. MIC has envisioned encouraging creation of institutions innovation council IICs across selected HEIs. A network of IICs is established to promote innovation and entrepreneurship in the institution through multitudinous modes, leading to an innovation promotion ecosystem in the campuses. MIC has established Institutions Innovation Council in more than 2,700 institutions till December 2021.
Hansraj College had established Institutions Innovation Council in the year 2019 under the guidelines of Ministry of Education's Innovation Cell (MIC) with the purpose to stimulate innovation and entrepreneurship at college level. The IIC of our college has various faculties from the various disciplines such as science, arts, and commerce as its member, along with students from different disciplines as representatives. We are organizing many activities, workshops, seminars under IIC HRC. The main idea behind organizing such events is to inculcate the sense of creativity, team building, and entrepreneurship into the young minds of undergraduate students. Under the Hansraj chapter of IIC, several innovations and varying webinars have been organized, ranging from Startup India, Mushroom Cultivation Center, and Go to Pitch to IPR awareness program and solar LED. The prime objective of all these activities and several others held under the aegis of IIC is aimed towards development and encouragement of innovation among students.
Today's session is being organized under an Impact Lecture Series scheme for IIC institutions. Recently, Hansraj College has been selected for the financial assistance for organizing Impact Lecture sessions by inviting external experts on innovation, IPR, and startup. These sessions intend to generate awareness and skill on INE and IPR among students and faculties of IIC institutes. In this regard, today we have organized the very first session of this series on IPR. Dr. Indra Dwivedi and Dr. Rekha Chaturvedi would be the eminent speakers of the day. Professor Dr. Rama, the principal of Hansraj College, is the president, and Ms. Alka Kakkar is the vice president of IIC HRC. Dr. Archana Singh is the convener of the IIC HRC, and Dr. Monica Kaul is IPR activity coordinator. Now, I would like to invite Monica ma'am to say few words.
Thank you so much. I welcome you all to today's morning session. As both of you have clearly depicted that what is the mandate of IPR Cell Institution Innovation Council and this lecture series very clearly. Both of you have mentioned that our main aim is to foster innovation culture in our own organization and also try to build an ecosystem around so that we also influence those who are coming in touch with us and try to build that innovation culture amongst our society as well. As an educational institution, Hansraj College has always been a lead player in major government initiatives. This initiative of setting up innovation cells in colleges is a welcome step. We believe that we have the young and the brightest minds of the country with us, and guiding them and preparing them for the future is our fundamental duty. Through this cell, we are trying to create that kind of an environment in the college. Though our curriculum is highly extensive, but I still feel that our students have so much impetus to learn many other things. Many of the students have that extra edge as well, and they are always looking for something uh, different than their curriculum. So this cell also provides a platform to all those who may not necessarily be scoring very high in their academics, but have that, that uh, aspect of innovation in their minds. We see most of the people who have innovated have not been the toppers as well. So we are trying to look for those students who know how to ask questions and how to design solutions for the existing problems. And through this impact lecture series, which has been funded also by the Government of India Ministry of Education, we have taken this responsibility that we will organize a series of lectures, and those lectures will be focused on innovation, IPR, as well as entrepreneurship. We'll do our best to ensure that this scheme uh, and the mandate of this scheme is passed forward, and through an expert panel whom you will be meeting off and on now uh, on the online platform, we will have new ideas, and we'll also know how to be a part of the entire gamut of Government of India policies, and how we can contribute at our own level and make our country proud and do something. Our students can innovate and add to what is the most needed aspect in today's culture. So with these words, I thank the Innovation Cell Hansraj College, our coordinator, our principal, ma'am, our vice principal, and all the team members who are working very hard to ensure that we all together uh, make this platform useful for the students. I would again say that this is meant for students, and as many students join us, our initiative or endeavor will be successful. So I want our students to interact with the experts and understand the facets of today's theme. Today's theme is IPR, and we have both the experts who have spent almost entire lives of their career uh, uh, dealing with all kinds of innovation policies, patents, and other aspects. Ma'am has worked with CSIR, so I am sure you'll have a full-fledged introduction of her after I stop. So thank you so much, everyone, and the team IIC for giving me this platform to introduce what we are going to have in this Impact Lecture series. This is our introductory and first lecture series. So I congratulate everyone, and I thank our principal for setting the platform for all this. Thank you, everyone. Thanks.
Thank you so much, ma'am. Now, with sheer delectation and ecstasy, we would love to introduce you all with the eminent speaker of our event. So, we have among us Dr. Indra Dwivedi, who is a former chief scientist and group leader of Patent Innovation Protection Unit, CSIR IPU. She is a qualified and registered patent agent under Section 126 Rule 110 of Team IPU. She has a great experience of 25 years in different capacities, having been involved in the plenty of technical and administrative roles. Ma'am also has a profound R&D background and experience in the field of chemical sciences, particularly in the field of drug development at CDRI Lucknow and the Epley Cancer Research Institute, Omaha, USA. She has more than 25 research publications and 2 patents in various international and national journals. Ma'am, indeed you have been a guiding light for all of us, and it gives us immense pleasure to enjoy your presence. May I now request Dr. Indra Dwivedi to kindly deliver the lecture.
Thank you, Vanshika, for kind introduction. I must thank Dr. Monica Kaul for inviting me as expert in this lecture series. And I am always excited and very happy to interact with the students uh, when and sharing my experiences, long experience in generation of IP, as well as in production at CSIR throughout my life. Are you able to hear me?
Yes, ma'am, very
Yeah.
clearly. Yeah,
Okay.
you're
So I have been a part and parcel of the CSIR system, starting from CDRI to CSIR headquarter, Innovation Protection Unit. So I'm very thankful to CSIR also and providing this opportunity in throughout my career, which I'm making use to share my experience with other organization and students. Um, I just want to tell you, India has always been creative and innovative. There has been abundance of creativity among the people of India. They are always creative and innovative, but these energies are flowing throughout the country, starting from villages to the cities. But I have seen these energies or the creativity is not protected. There are several reasons for that. First is the lack of awareness of IP protection. Sometimes it is realized that it is not required to protect it, or they are sometimes people think it is a very cumbersome process or it is a complicated process, legal process. So they don't care about the protection of IP. But I must tell you, this is very important subject nowadays. For last couple of years, government of India is doing very hard to make aware people about the IP and about the importance of IP, how to protect it, and how um, to exploit it, IP. So realizing the importance of IP, they have Indian government has done a major task, starting from enactment of the IP laws during 1999 to 2001. Number of new laws they came up. Several these amendments of IP laws were also done during this period. And also realizing the importance of IP, National IPR policy was formulated in 2016. So, uh, um, and it was beautifully depicted in the IPR policy, National IPR policy, that this subject, intellectual property rights, will be the subject of will be a part of the curriculum at all levels of the educational institutions, starting from the school level. I understand it has been implemented, or it is being implemented in schools as a part of curriculum. And I can see from this seminar, even I know this student Vanshika, she was telling about the implementation about the this importance of IPR in Hansraj College itself. I got to know from you only. It is IPR cell is already established. This is because the IPR policy is formulated and it is being implemented. And you see, after 5 years, this IPR policy has been reviewed by the government of India. And if major steps are not taken, they are taking major steps to make the people of India aware about importance of IP. So let me start with the topic of this today. Topic of today, that is the IPR. What IPR is? I will be giving you the flavor of IPR. Just a minute. Uh, Slide is not moving.
abhi to nahi move
Yeah,
kar rahi,
yeah,
ma'am.
yeah, yeah. It is. It is.
Yeah, now it is. Now it is
Yeah,
there.
yeah. let me start with the topic, what is intellectual property? And I will be talking about the different kinds of intellectual property, and then I will be focusing more about the patents. I will give the flavor of importance of intellectual property. Actually, what refers to intellectual property? What do you mean by what do you understand about the intellectual property? There are different kinds of property: physical property, intellectual property, and all. So intellectual property is a creation of mind. What mind creates, that is invention, literary and artistic work, symbols, names, images, or any other product or process that is created through the human intellect is called as intellectual property. That can be protected. That particular work will be protected by these species of IP. I will be talking about that. What are the species? There are two categories of intellectual properties, that is industrial property and the copyright. In copyright covers the literature work or literary work such as novels, poems, films, music, artists, whatever you are making, paintings, photographs, all these, they come under the Copyright Act. Or Copyright Act, they can be protected. And the industrial property covers the patents for inventions, trademarks, design, industrial designs, plant varieties, geographical indications. All these are the intellectual property. So come to the products of IPR in daily life. We are always surrounded by IPRs. Means when you are getting up in the morning, you are using the products starting from your day and until you sleep. You are using the products which are protected by IP, that is intellectual property. So when you wake up, what you do? You use the toothpaste of different brands. All this is an intellectual property. This Colgate, Pepsodent, whatever toothpaste you are using, Patanjali toothpaste, even everything is patent protected, or the trademark or copyright or design, everything is protected by IP. So we cannot avoid it. Then you start with having tea or coffee, Darjeeling tea, Taj Mahal, Nescafe, all these are the trademarks. This is also a kind of intellectual property. Wearing branded shoes, clothes, you start your day using these things and go to school or college or offices. You are using everywhere the products which are protected by IP. Breakfast, Amul milk, buttermilk, or whatever. Kellogg's is a very big brand. Harvest Gold, all these are having the protected by IPs. Using vehicles, all vehicles are protected by IP, patents, copyright, trademark, everything is there. In school or colleges, you are using computers, laptops, for pen, pencil, stationery, whatever you are using, everything is protected by IP. Again, coming to home and sleeping on sleep well mattresses or any bed or anything, that is also protected by IP. That means you cannot avoid the understanding of IPR, how important it is. Now come to the importance of IPR in a little detailed manner. That is, it provides incentive to individual for new creations. That means if you have created a new thing, you will be having incentive for that. If you are getting the IPR, you will have different advantages of IPR in different sectors, providing due recognition to the creators and inventors. Like if you write a patent, if you write a publication, you will be recognized not only by publication, but having a patent or any IPR, you will be recognized in a business, in your business or in any other sectors. It will be recognized, ensuring the availability of the original products. If your product is patent protected or any other IP product, protected product is there in the market, it will ensure the originality of the product. For economic growth and advancement in technology center, protection of intellectual property protection is important. That is the reason it is very important. They are benefited for the growth of the business in the field of technology. Enhances the value, company value. If you are having a patent protected product of your company or your organization, you have much more value than the without IP protected company. You may be aware that many big companies, Microsoft or any a big Google or Amazon or all, they are protecting their values. They are more than 95% asset is intangible asset, that is IP, and only the less than 5% of the value of the physical assets. So you just realize the importance of IP, how important it is. IP stop unauthorized use of inventions for making, selling, using, and importing. This is the most important thing. I will be discussing about this after few minutes. Indication pending patent on the product support the sales. If you are putting a this word pending patent on the product, if you have a product in the market, definitely it will support the sales. It will enhance the sale because people will realize this is an original product. There will not be any cheating, so they will buy that, and this will enhance the sales. Reduce the possibility of theft of important knowledge by the employees. If you are keeping the secret of your things, the business or the product, then it may be a possibility of theft of by the employees itself. So it is better to protect it always. IP plays a key role in driving innovation and economic growth. Uh, it is very clear nowadays because if you are having IP protected thing, innovation will be more. It will be in public domain. It will definitely increase the economic growth, turn the innovative ideas into profit, marketing of business goods and services. Definitely it will be increased, as I told you. Access or raise finance for the business. If you have a patent for a product or any other IP, you can put in your proposal uh, for the making proposal for fundraising. You can put into the proposal for fundraising. Even banks, they will give you the finances for the business. Improve the export opportunities for the business. Definitely, if you are your IP is there, product is IP protected, you will be attracted by the foreign parties. You will have more business. Secure the unique ideas and creation. It is the basic idea actually. Accelerates the business growth by these things, and IPR strengthen trade, FDI, and technology transfer. You will have more opportunities to have the technology transfer. If you have a technology for suppose any vaccine, if it is protected, definitely, or any other drug or any product, if you have IP or patent protected, it will attract the technology transfer possibilities. Let me talk about the different species of IP. There are different species. A product can be protected by different species. Patents, trademark, copyright, trade secret, designs, plant varieties, geographical indication, semiconductor integrated circuits layout designs. There are different laws for protecting the product or the processes under these species of IP. These are the governing laws in India for IPR. Patents Act is 1970, and other acts are also 1990, 57. Geographical indication, they all are around this 2099, 2000. All these laws are already there in place in India. So I just want to make it clear for you. Maybe you are aware. It is a very simple example I have taken. One product, Coca-Cola, everybody love to use it or to drink it. It is trade secret. The formulation of this product is trade secret. After 125 years, old product is there in the market, and it has a very strong trademark. Coca-Cola is very popular, and it has a great value of this organization. Coca-Cola, this bottle, if you see, you will see this product is protected by different ways of IPs. Trademark is the strongest trademark, and the design registration. Design of the bottle, which is appealing to the eyes, and it's a small bottle containing this formulation, which is trade secret formulation. Nobody knows about it except few people of the organization. And this is a trade secret protected under the trade secret. Design of the bottle is protected under the design law, and the patent, this lid which is kept on this bottle is it may be a patent protected, or it may be the design protected, because it has small, these ribs are there. Similarly on the bottles, the ribs are there, so nobody can copy this product or even the design of the bottle for their product. So this is the purpose of the IPR protection for a product when you are putting it in the market. So that means I just want to tell you, one product can be protected by many IPs. That is, this bottle is protected as a trademark, design, trade secret, and patents. And maybe the brochure of any of these things can be protected by this copyright. I just want to give you another example here. A car, it is a vehicle, it is having multiple components in the car. This car can be protected by many IPs, not only just one patent or trademark or any design. These are protected under different IPs. So patent can protect a new technical feature of the car. That means suppose somebody has come up with a engine, or which is having new feature. Because of that new feature, it is fuel efficient, or it is releasing less pollution in the environment. This part can be protected under Patents Act. Trademark, you know already, trademarks are there in different trademarks for the vehicles, cars, Toyota, Mercedes, Benz, and Innova, and Maruti. All they are registered trademarks. And design is very important. Design of the car or any product can be registered under the Design Act. Because when you go to the market and purchase a product like car, this if you don't like the design, definitely you will go for another one which you like it. So the importance of design protection is very important. So nobody can copy the design of your car or any other product. So design registration is very, very important. Copyright, definitely you have the written material on the brochure of the car that can be protected by the copyright. Nobody can copy it. So one product or the different kinds of IPs can protect your product. It is better to protect it. I have just given a simple example. As a student, you may like to have the bicycles. Bicycles, they are unique features of the bicycle. Just I'm giving example. They may be registered. They are unique, novel, or distinct. If you have any item of novelty is there, uniqueness is there, and then it is appealing to the eyes, and it is a distinct, you can have registration as a design registration. Here, I just want to give you the classes of works for copyright. Copyright, original literary work, dramatic, musical, and artistic work can be protected under the copyright. Similarly here, cinematographic films, you are always knowing it. I am sure everybody is know about it. This is general knowledge. Just copy, these films cannot be copied. That is protected under copyright, and sound recordings, songs, and all. And similarly here, softwares are also protected under copyright. I just want to give you the development of patenting in India. This little bit history, because all the information is available already on the website of any IP website. Is the IP India website is available. But I would say just I will give you a little bit about the history of Indian patent system. Before independence, there was Patents Act was there in 1856. It is very old in a British period. So and first act was there in 1856, followed by Patent and Design Act 1911. And after independence, India has realized the importance of IP. You see, India has been already realizing the importance and started working at that point of time after the independence immediately. And amendments were carried out in the Patents Act, and several amendments were done in the interest of public interest. And then I just want to tell you, this is the most important thing here. In 1970, this Patents Act came where no product claim for the food and medicine and the products which are prepared by chemical reactions. It was intentionally, it was put in the Patents Act. No product claim for the food and medicine. And the term of the patent was only 7 years. And for other people, other products, it was 14 years. For drug and medicine, food, drug and medicine, it was only 7 years. So almost for medicine or drugs, or food, there was almost, you can say it was not protection was not there. Only the process patents were granted that time. And after this 1972-94, what happened? Indian industries, they started working very hard, and they strengthened their capabilities in the field of pharmaceutical development, new products, and they were making, they have improved their capabilities, and they became self-sufficient. And during this period, this India became the largest exporter of generic medicine to the world. So India is known as world pharmacy. Now you may be already knowing in news and newspapers and all debates, and India is known as world pharmacy. They have provided already they were providing the vaccines and other medicines generic to all over the world. But recently, for last 3 years, during this pandemic period, India became a leader in providing the vaccines and other related COVID treatment drugs and other things also to the world, because they are self-sufficient Indian pharmaceutical companies, and because of this reason, there was no patent act, product patent was not there. The Indian pharmaceutical companies, they worked very hard, and they became self-sufficient. They started doing this. In 1995, the WTO came, and India became member of 1995. So we were supposed to have the product claim like other countries they were having, and we started working on the amendments. For the act was done in 1999, 2002, and 2005. And after that, we have to give India has to give the protection for the molecules, products in relation to food and drug also, as for other products. So, I think these are the amendments which 1999, 2002 Indian Patents Act was amended 3 times in phase-wise manner, and now this our patent system is as good as any other patent system, like in US or UK or any other country. CSIR has been already having this IP unit in India. This is the oldest unit in CSIR. For protection of IP, CSIR realized the importance of IPR, and even before independence. Let us think about why is patent protection required. You see, when you file a patent application, you have to disclose your invention. That is the most important thing required. This is the philosophy of the patent system. You have to disclose your invention, which you have invented, completely in the specification or the document which you are going to submit in the patent office. So this patent document itself is having very rich scientific and technical information in the document. So what will happen? They will be published in the patent office website, and people will read it, and they will be encouraged to have more inventive activities. So this is the philosophy of the patent system. You have to disclose it. The government will provide you the incentive for that, for protecting the invention. And this information will be inspiring the people to produce more invention, and that will be the benefit of the nation. So this is the beautiful philosophy of the patent system, which is already laid down in the Patents Act. You can read it. IP offices in India. How many IP offices and where they are located? IP offices in India, they comes under the Ministry of Commerce and Industry, Department of Promotion of Industry and Internal Trade, DPIIT. And there are 4 IP offices. Kolkata is a head office, Delhi, Mumbai, and Chennai. These are the branch offices, Delhi, Mumbai, and Chennai. Kolkata is the head office. And trademark registry is also there in all these offices, all 4 places. Ahmedabad is another one. And another design registry is in Kolkata. Although you can file design registration in through Delhi Patent Office, no problem. GI registry is in Chennai. GI means Geographical Indication Registry, that is in Chennai. Copyright registry is in Delhi, and this is a Nagpur is a training center. How filing of a patent can be done? I'm just focusing on only on this patent. Although all these filings can be done in all IP offices, except the GI and other. Just a minute. Yes, filing of application can be done by 3 different ways actually. You can prepare your document, which is to be filed in any patent office, go physically and submit it to the office and get the receipt and all. You have to submit the fee along with the documents. Another thing is electronic filing. Electronic filing is very easy. You can go to the portal of IP India online and file the application electronically. You will get the number, and then you have to submit the fee, and everything is electronic. And you can also file the application by post. You can send it through by post. So I think the electronic filing is the best one. And where should patents be filed? The appropriate office of patent filing has to be done in the branch office, as the case where should patents be filed, maybe within territorial limits, because this is a territorial thing, which if you are in North India, you have to file in Delhi Patent Office. If you are in South, you have to file in Chennai. Similarly here in Mumbai and Kolkata. So these are the jurisdictions divided here. Territorial jurisdiction are provided here in the Patents Act already, where you should file, because this is very, very important. If you are filing wrongly, if you are patent is coming out in Delhi and you are living in Delhi or in any North Indian state, definitely you have to file in New Delhi. If you are filing in Chennai, suppose, it will be wrong. It will be an invalidate. It will be challengeable. So always think before filing the application where you should file. If you are filing in Mumbai, definitely it will be a wrong filing. So you can residence of applicant or domicile. If you are doing your business in that particular state, you have to file accordingly. And if you are not in, suppose India, if you are outside, you have to give the address of the business in India. Then you will be able to file the application. So this is very important. These are legal things, but you should know before you file them. As I told you, this is a national right. It is a territorial right. Suppose if you are planning to file the patent application in India, you have a right only in India. Means you have a right, exclusive right. What it gives, the patent gives you the exclusive right. That is only in India. It does not mean you have filed the application in India and you are claiming you have a patent, so you cannot you can exploit it in US. No, you have to file application in different countries. If you are planning to have business over there, then you should file outside India accordingly. You need to get patent in each country separately. So there are certain ways how to file for an application. That is some patent cooperation treaty is there. India is a member of that. And Paris Convention. Under this Paris Convention, if you file the application in one country, you have 12 months of time to file the application, taking priority from other application, the first application. So what is a patent actually? I just make it clear to you. It is a statutory right to the inventor or the applicant by the government for his invention, which is either a new process or product. Means if you have a new process or any new product, you are given the exclusive right by the government. If you file the application, if your application is granted, you have a exclusive right in a legal document issued by the patent office. It is granted in why government is giving you the exclusive right, because you have disclosed the information in the patent document. It is granted in lieu of sufficient disclosure to the patent officer. Granted to limited period means the term of the patent is 20 years from the date of filing. Suppose if you file today application, you have exclusive right for 20 years after the grant, after the filing of the application. Today, then 20 years from the date of filing. Confined within the geographical limit of the country. If it is filed in India, you have a right only in India. That is territorial right. You cannot claim in other country. Patent enables its owner to exclude others from exploiting the invention in the territory for which it has been granted. You have exclusive right in that particular territory. You can exclude others for making use of your invention. You can. This is an exclusive right given by the patent. Now, as I told you, unauthorized third party cannot make use of your invention. You can stop it for making, using, offering for sale, selling, importing, or distributing your patent protected product. You can have the enforcement right. So what does a patent do? It is a techno-legal business document. When you write a patent application, keep in mind it is a technical legal business document. Patent writing itself is a very specialized work. It comes through the experience while writing or reading the patent document. This document protects you 20 years or protects the invention for 20 years from the date of filing. Nobody can manufacture it without your permission, without the permission of the owner of the patent. Someone can you can license it, or you can have the royalties for the licensing your product or for your patent. You can block competitors, definitely. If somebody is competing you, your patent can be blocking. By way of blocking your patent, you can have the licensing opportunity or negotiation with the other parties, competitors. After 20 years, technology goes to public domain. After the expiry of the term of the patent, it goes to the public domain. That means anybody can make use of your invention. They are free to use. They need not to take any permission from the patent holder. Patent rights, what it patent rights, it is the definition given in the Patents Act. I'm just not reading it. I'm just telling you, if you have a product patent or the process patent, both you are getting the exclusive right to prevent third parties. Without consent, nobody can make use of your making, using, offering for sale. You can take the action against them. This is the right given in the patent granted for granted patents. As I told you, patent owner of the patent has two kinds of rights, that is licensing rights and the enforcement right. You can have the license, you can give the license to use your invention to for practicing the invention to someone if you think he or she is able to do it. You just like a physical property. If you have a land or house, you can give for the rent. You just put your flat on the rent. That means you are giving license for using your flat, and they are providing the rent. Similarly here, if you have a patent, you can license it for making use of the invention. So, and they can pay you the royalty. Similarly here, enforcement rights, you have enforcement rights. Means If somebody is making misuse of your invention, that means without permission, if they are making use of your invention, you have a legal right to stop that. Patent gives you the exclusive right for uh, for to stop others for making the invention, for making use of your invention, but it is not an absolute right. Absolute right, a patent cannot be an absolute right. Means, I just give you example here. If you have a patent for a vaccine, it is very good, better than any other vaccine in the market. And then there is a pandemic, like for last more than 3 years we are facing here and all over the world. If I am having a patent for a vaccine which is better than any other vaccine, and I don't want to give license to anyone, I just want to keep it itself, then government has right to take that exclusivity right given by the government. They can make use of your patent for government use, importation or manufacture on behalf of the government for experimental purpose, research purpose, teaching purpose, distribution of drug or medicine by government in dispensaries, hospitals. Nobody can stop that. So government has all full right to make use of your invention in the public interest, like in a pandemic situation, as several examples were there. What is an invention? It is a definition given in the Patents Act. Invention means a new product or process involving an inventive step and capable of industrial application. This is the definition. That means if you have a product or any new process, which is having inventive step and capable of industrial application, is an invention. All inventions are all things will not be considered as invention. Only the product which is new, it involves inventive step and capable of industrial application will be considered as invention. And what is inventive step? Means a feature of an invention that involves technical advance as compared to the existing knowledge, or having economic significance, or both, which makes the invention not obvious to persons skilled in the art. This is the definition provided here. I will tell you here the requirement of patentability. Just try to remember, to have your patentable invention, you must check whether your invention is novel, inventive, or having any utility. Three things should be there. If any of these three is missing, this invention will not be patentable. If you want to file a patent application, it should be novel. It should not be published in anywhere in the world. And it should be inventive. It should not be obvious to a person skilled in the art. Means, by looking at the literature, if you come out some invention which is very much obvious, looking at the prior art, it will not be inventive. And if it is not having any utility, then it will also not be patentable. I have seen many patent applications when I was in CSIR handling IPR patent applications, where people have submitted the document where there is no utility is given, because that was a side product prepared in the during the process of making some other product. Some other new product has come that may be novel, may be inventive, but if utility is not established, it will not be patentable. So always keep in mind three things: novelty, inventive step, and utility. It is most important to have a patentable invention. We will talk about what is not patentable in details after some time. How to judge the novelty of the invention? It should not be published in anywhere in the world, not only in India. It should not be published in anywhere in the world. It should not be in public domain. It should not be in a public use. It should not be public knowledge. It should not be claimed in any specification of the patent document. So this is, you have to make the prior art search before you make an application to establish the novelty of the invention. How to judge it? You have to do the prior art search. There are a number of different databases are available, paid or unpaid or Google search or anywhere. All in this digital world, it is very easy to find the solution for the novelty, whether your product which you are going to have the patent application for that is a novel or not. You check before filing the application. Otherwise, what will happen? You will lose money, time, and efforts for filing the application. So what is prior art? It is important to understand the prior art. What is prior art? Prior art means which is already known. Any information disclosed to the public anywhere in the world in written form or oral communication by display or through public use constitutes prior art. In public use, suppose I just want to give you the example here. Vaccine, this any vaccine is which we are Indian vaccine. We have got this vaccine and immediately we started this putting vaccination in the public. If a patent is not filed, it will be called as public use. It is in public use already before filing the patent application. So this should not happen actually. But during this pandemic situation, the time was very small. And if it happens, the public use before filing the patent application, it may be exempted by the government. So there may not be problem, but there is a provision, and I will be talking about in detail. There is a provision in the Patents Act also for public use. I just want to make it clear to you. There is a section of 31 under section 31 of Indian Patents Act. There is a provision for public display. As a researcher, you are always excited to display or publish it or present some research work in a this thing conferences. It is very common among the researchers. But please keep in mind before you publish it or before you present in the exhibition or anywhere. You should not do it. If it is required, you have to take. You have to see this provision is very restricted. People think about it. 12 months period is there, but actually it is not there. It is written here only the exhibition notified by central government in official gazette. Publication of invention in consequences of above said exhibition or use during this exhibition will be exempted if the patent application is filed from the within the 12 months period from the date of exhibition or paper read by inventor before a learned society or published in the transaction of the society. If you have presented a paper and 12 months of time, if you have filed the application, it may be allowed, maybe the interpretation by the examiner or the controller may be a little bit different. Sometimes they do it, but actually this is a very restricted grace period. 12 months, it is a central government official gazette and all these restrictions are there. So don't do this. If you are making an application, you just file the application, provisional application before any public disclosure. That means if you are reading the paper or exhibition or if you're displaying the product in somewhere, file provisional application and within 12 months of time you can file the complete specification to save you invention. I just want to tell you, I have taken an example here. Compound, suppose I'm a chemist, so I understand many of the students are chemists also or biologists, they can understand very well. If there is a prior art, if find a document which is compound is already known in the art and prior art discloses many pharmaceutically acceptable salts of the compound X, including fumaric acid, but there is no specific disclosure is provided for the fumaric acid. Even then, just displaying or saying in a statement that pharmaceutically acceptable salt of the compound X of fumaric acid, including fumaric acid, although no disclosure is provided, it will be considered as a prior art. No disclosure is provided, but only one line is there. Implicit disclosure of prior art anticipate the novelty of the invention. So it will destroy the novelty of your product. So consider before filing the application this kind of document. What is an inventive step? I think I should hurry. 10:55 already. What is an inventive step? Inventive step involves a technical advancement. Um, any new feature of the invention which involves technical advancement and economical significance, which makes the invention not obvious to a person skilled in the art, will be considered as inventive step. I just want to give you one example here. This process of defluoridation of water. Being a chemist, you will be able to understand. Fluoride content of the water in a process. Suppose you have come up with a process of defluoridation of water. Then if you are having
बहुत सारे students chemistry के हैं. So
अच्छा
you
अच्छा
can go on.
very good. So how many minutes I can take?
Ma'am, I think 11:15 is it?
15. I think I will speed up. I'm just
11:15 तक तो मैम टाइम है ही है.
okay, okay, no problem. No problem. So I have taken a simple example, defluoridation of water. I'm just telling you this example, how to judge the inventive step your process or the product. Suppose you are reducing the fluoride content in the water because it is a toxic element in water, health hazardous. So you have to defluorinate the water. How to judge whether your process is inventive or not? Suppose there are three steps which are important here. The treatment of water with calcined eggshell powder added in a step. Another step is treatment with aluminum nitrate. And then another step is alum is added and agitated in for a different time period. Suppose these three steps are already known in the art in a single step somewhere. Then what you are doing, you are combining these three steps in a single process. By combining this, if you are getting some unexpected result, suppose if you are totally eliminating the fluoride content of the water, then it will be called as inventive, because you may be changing something in the process and you are making change in the time period or in a amount of this thing. Or if suppose calcined egg is replaced by the activated carbon, maybe um, it is already known carbon, the activated carbon for removal of fluoride content. So when you have to take the totality of the process, what are the unexpected result you are getting, which are not present in the prior art, or the teachings are not there for combining these steps, then it will be called as inventive. Otherwise, routine process combining these steps in a single process, there is no advantage. Then it is not inventive. It lacks inventive step. So you have to judge the inventive step in this manner. And the third thing which I told you, novelty, inventive step, and utility. Your product or process should be capable of being made or used in any kind of industry. If it is not useful, then it will not be patentable. What can be the subject matter for patent? Any machine, system, process, article, or chemical substance, biotechnical inventions, all they are patentable subject matter. Anything around you, everything is patentable, but not all the inventions are patentable. I will talking to you after this, I think. What can be patented? As I told you, any machinery, any component, any substance, living, non-living, or pharmaceutical product. Non-living in India, living things are not patentable, but this definition tells you the living in other countries, they are patentable. Non-living product or pharmaceutical product, any composition of matter, pharmaceutical product, any process, anything. Just given the example here, the pen, writing device, you can have patent for any multiple patents for one pen. If you have another important improvement, you can have another patent. Here I have taken a machine, sewing machine, thousands of patents may be there for machines here. And similarly, this is a molecule developed by CDRI. I was working on this. This is a favorite of my research. This thing, several patents were there. Similarly, BGR34 is a formulation for diabetic patients. So all are patent protected. Anything can be protected where there is a human intervention. As I told you, any process or product should be novel, inventive, industrial application. This makes the invention patentable. But you should check whether your invention is falling under Section 3 or 4 of Indian Patents Act. Because Section 3 and 4, they are not patentable inventions. India has Indian patents has Section 3 and 4, where the patents are not patentable. So I will be talking in detail about the inventions falling within the scope of Section 3. Inventions falling under Section 4, these are radioactive compounds or under Atomic Energy Act. They are not patentable, radioactive because of hazardous things. They are not patentable subject matter. I will be talking about the what are not patentable. I talked about the what is patentable, which is novel, inventive, and useful, is a patentable subject matter. What under the law, what are not patentable? That is, there are several inventions. They are inventions, but they are not patentable, kept in the Patents Act. Which is frivolous, invention which is frivolous, obviously contrary to well-established natural laws and contrary public order or morality, or causes serious prejudice, any environmental health hazards. These inventions, they are not patentable. Suppose if you have invention to increase the air pollution, water pollution, which is hazardous for the general public or the environment, it is not a patentable subject matter. But if you have a process of reducing these things, definitely it will be. Mere discovery of scientific principle or formulation of invention, abstract theory, living or non-living, they are not patentable subject matter. This is Section 3D of Indian Patents Act is very, very important. I will be giving you some examples. New form of a known substance which does not result in the enhancement of the known efficacy. It is not a patentable subject matter. It is not patentable. I will give you some example of that. And mere discovery of mere admixture resulting only mixing of things, just mixing of things, there is no enhancement in the efficacy or thing, will not patentable. Mere arrangement, rearrangement of duplication of known devices. If you are putting one device or connecting to others, there is no advantage of that. There is no enhancement in the functioning of independently or one another, then it will not be. Method of agriculture, horticulture is not patentable. However, the instruments used for this or the formulations used, they are different things. They can be patent, they are patentable subject matter, but method of using them in agriculture or horticulture is not patentable. Any process for medical, surgical, curative, diagnostic, they are not patentable subject matter. But method of treatment of plants is patentable. Plant, the amendment was done, that time it was included. Method of treatment of plant is a patentable subject matter. Plants and animal as a whole, they are not patentable, but microorganisms are patentable. Seeds, varieties, they are not patentable, but seeds and these varieties are patentable under the Variety Act, Plant Variety Act. They are not patentable, but they are registered plant varieties in India. But in different countries, in US and other UK, they are patentable subject matter also. It depends on country to country. Mathematical, business methods, computer programs are not patentable, literary, and a whole list is there. I'm not going to read it. Then I would suggest you to read this section, Section 3. It is very important when you are having your invention. Just interpret your invention in this Section 3 where you are falling. An invention, I just want to tell you Section 3P, which is very important to understand. An invention which in effect is traditional knowledge, or which is an aggregation or duplication of known properties of traditionally known components of, they are not patentable. But it does not mean you are using the traditional knowledge, making some other product which is useful. You have done a lot of work based on the traditional knowledge. It is a patentable subject matter. But as such, if you are using the traditional knowledge and making the file, making a patent out of it, it is not a patentable subject matter. As I told you, Section 4 of Atomic Energy Act is not patentable because it is hazardous. And what you can claim product claim for, in case of the drugs, you can have new chemical entity, formulations, compositions, combination of drugs, new form of known substances. kits can be claimed, claim for process for preparation of a drug, claim related to new property of new use of substances. This claim, I'm telling you the fourth number, it is not patentable in India, but it is patentable in some other countries. Method of, I'm telling you here the general, I'm not specific to India only. The claims, what is patentable, what is not patentable depends on the that particular Patents Act actually. Method of treatment is not patentable in India, but in other countries it is. Diagnosis of disease of human beings is patentable in other countries, not in India. In biotech inventions, you can have different kinds of claims for all these products. You can have a claim for this thing. Polypeptides, genes, proteins, the host cell, plant, animal, tissue culture. But these things are very restricted here in India. Pharmaceutical vaccines, they are patentable. Vaccine compositions, microorganisms, proteins, antibodies, diagnostic kits, they are very well protected. And diagnostic a test for mutation of gene, all this is patentable subject matter. You can have a claim for this thing. Method of diagnosis of a label of glioblastoma is also patentable subject matter. You can have a claim for that. I was telling you about the section 3D, particularly for the students who are having chemistry background, as Dr. Monica told me. It is very important to understand here the section 3D. When you are making an application for a molecule, you must see whether it is patentable under section 3D. And if it is not, then how you can make it patentable. Mere discovery of section 3D says mere discovery of new form of a known substance does not result in the enhancement of the known efficacy of the substance or the mere discovery of any new property. You can read this 3 times, at least 4 times, just understand it. I will tell you the reason. If you have a product already known in the market, but if you have come out with a new salt or ester or ether, here explanation is given here, or you have isolated or separated the isomers, that will not be patentable judgment because it is already existing in a mixture. So you have just isolated that mixture. So for process of isolation, you can have a claim, but the product will not be allowed until you show the advantages, you show the enhancement in the efficacy of that product. Why you are doing this? If you are isolating that compound or the isomers, you have to give the enhancement in the data for showing that it is enhanced property is there. So you should understand section 3D very well. I will give you an example for this. I just want to give you here 2DG drug. It is very well known for everyone for last 3 years because nobody knows before this, but it is a known molecule. You may be knowing it. It is a 2-deoxyglucose for the treatment of COVID-19. DRDO has come out with this drug, and this is a known molecule. It came into in my mind that time whether we can have the patent for this. No, because under section 3D, it cannot be because it is an already known thing. So no product claim, we cannot have the claim for the product. And new use means for the known compound, new use means it is a treatment of COVID-19. So COVID-19, it was not tested before. It is first time it is tested here by DRDO, and they have come out. This is a successful drug, but it is not patentable because it is a new use of a known substance. It is not patentable under section 3D. And method of treatment, 3 kinds of claims can be prepared. Molecule is not novel, no product claim can be there. New use of known substance, not patentable under section 3D. Method of treating COVID-19 using 2DG is not patentable subject matter because method of treating is excluded under section 3 category of inventions. It is not patentable subject matter. And but of course, if 2-deoxyglucose process is there, preparation of this molecule, if somebody has come out with a very cost-effective method of preparation of this compound, it will be a patentable subject matter. But I have not searched for this process. I'm just telling you the process can be patented if it is novel, inventive, and utility. It is established, then it will be patentable. But how can you make it patentable if you have come out with this drug, if you are making a synergistic formulation of this 2DG with any other molecule, which is more effective for the treatment of any disease or COVID-19, it will be a subject.
हेलो हेलो आवाज चली गई क्या
For
मैम की
myeloid leukemia, and it is a filed. This application was filed in 1998 in Chennai Patent Office. Beta crystalline form of methane sulfonic acid of this molecule. Alpha was already known before this filing the application. So what happened? They have removed the problems associated with alpha in this molecule, beta crystalline form, and they filed the application all over the world, many countries, including in India. But India was not giving the product claim for because Act was not providing the product claim that time. So what happened when it was examined after 1995? It was examined in 2005, and people was just looking forward to see what will happen to this case. It is very important molecule for the company. So what happened? It falls under the category of 3D invention, not patentable in India, because applicants or the inventors, they were not able. This company was not able to show the improvement in the enhancement in the efficacy of the beta form. So they were not able to provide the data, and this case went up to the Supreme Court. And Supreme Court has given decision in 2013. There is no sufficient bioavailability, sufficient enhancement in the efficacy of the beta crystalline form. So the application was not granted. This because this was falling under 3D, Section 3D of Indian Patents Act, which is not patentable if there is no enhancement in the efficacy as compared to the alpha form. So this is the thing. This is a landmark case in the history of Indian patent system. I just want to give you a simple example here. Mere admixture resulting only in the aggregation of the properties of the components. Section 3 of Indian Patents Act says if you are mixing 2 or 3 or 4 things, there should be synergism in the properties of the product. Suppose a simple example, this combiflam. Combiflam, what is that? This paracetamol and brufen combination. And if this antipyretic and analgesic property of the combiflam, this is all individually they are known. If you are combining and making composition as a combiflam, it is not a patentable subject matter until it is having better efficacy or it is having some other treatment. It will be patentable, but not as such. It is not a. As I told you, this section 3I of method of treatment claims, these things are not patentable. Method of surgical methods, curative methods, prophylactic, diagnostic methods, all these are not patentable. But any of the instrument used for these surgical methods or curative methods, or they are patentable subject matter. Only the method of cleaning of plaque from the teeth is not patentable, or making surgeries is not patentable. But if a doctor is putting the braces to the denture for cosmetic reason, it is a patentable subject matter. For cosmetic reason, if something is done on the body, is a patentable subject matter. Not for the therapeutic use, it is not a patentable subject matter. Patent may be obtained for the apparatus or instrument used for method of treatment. It is very clear now. Now, I just want to tell you 3P section is because a lot of research is being done by the students in the universities and institutions based on the traditional knowledge. But I just want to tell you assessment of patentability of invention should be done on the public knowledge or traditional knowledge. For example, use of turmeric for wound healing is already known for centuries. Use of Withenia somnifera as memory enhancer. If you are combining 2-3 components in a formulation and coming up with a better efficacy, or there is no teaching in the prior art or the knowledge combining of these products, this will be a patentable. But you have to show the utility and better efficacy and how it is different from the prior art. Then it will be a patent. Nobody is going to stop. Although it is falling under the traditional knowledge 3P, but you have done a lot of work after that. So it does not mean it is a traditional knowledge. So please don't stop doing research on traditional knowledge based formulations. It is important to have. Already, these things are as old as many centuries, but still a lot of scope is there to do research on this. I just want to give you a simple example here by CSIR. When I joined CSIR headquarters in 1995, what happened? A lot of people were working in this unit just for this turmeric. I was not aware about it, but you see, this patent was filed by two Indians in USPTO. The use of turmeric for wound healing properties. This was filed and it was granted by USPTO. US Patent Office granted this patent to two Indians for wound healing property of turmeric. CSIR noticed this, and it was decided by DG CSIR, Dr. Mashalkar, at that time. It is a wrong patent. We are the we are having a lot of knowledge this on traditional knowledge, and our knowledge is being exploited by others. So we will not do it. And the CSR challenged this patent based on the documents provided to USPTO, and a lot of translations and all these of the documents were provided to US Patent Office, and then they cancelled the patent because the ground was they failed to meet the novelty of the criteria of the patent. So this, I just want to tell you, based on just wound healing property is not patentable. But if you have isolated a compound, which is a novel compound, you have synthesized it, and you are having better properties, definitely you will get the patent for this. Similarly here, this is the recent case 2007. It was filed by Avasthajan Limited in Chennai Patent Office. Synergistic Ayurveda for functional food biocomposition for the treatment of diabetes, having these three components: jamun, longpati, and chandan. This was granted. It was granted, but after the grant, it was revoked by different companies because it is a traditional knowledge. It is already known. And based on this, European Patent Office also not granted this patent. It was revoked in India, and after that, European Patent Office did not grant this patent. So this is the thing. I think I'll hurry up. What I just want to tell you, filing a patent application is very, very important. You must know what is patentable, what is not patentable, and how to go about it. After that, you must know what are the legal requirements or the documents to be submitted in patent office. There are certain forms, application forms are to be submitted to the patent office, wherein you have to give the information. That should be very much correct, and it should be put through along with the documents, form 1, form 2, form 3, form. And there are two kinds of information: legal information and the technical information. Legal information is very, very important. Similarly, the technical information, which is very important in the form of a specification. It is a structured document, you can say. Form 2 is a structured document. It is called a specification, patent specification, where you have to disclose your invention in a proper format. This format will have the background of the invention, summary of the invention, claims, and abstract and drawings if it is required. So you have to write a patent specification in a particular fashion. Before you write, you read hundreds of patent documents first. Then you will be able to understand where you have to write and how to write it, and what is to be written, what is not to be written. It is also very important what you should not write in the patent specification, how it will be problematic in writing. It is a specialized art. I think it will, you have a legal cell, so they will tell you how to write the specification. And now I would go the main steps of patent procedure. When you file the application in the patent office, it will be published in the on the portal, on their website. It will be there after date of filing. 18 months from the date of filing, it will be published automatically. And you have to make the request for examination, and they will examine it, and they will send you the report, first examination report, then maybe second or third, and it will be granted. If it is granted, then pre-grant opposition period is there, and then you have to they have to, if there is no opposition from the public, it will be granted. Grant of application will be there. Then post grant opposition period is also 1 year, and after that it will be free. Means it is understood, it is not having any problem. So these are the simple steps I have given here: filing, a request for filing of for examination, publication by the patent office, then examination, and pre-grant opposition, post-grant opposition, and then it is granted. It is shown in the flow chart here. You can have the patent application provisional, as I told you. If you are in a hurry to disclose the invention to any meeting or any publication or exhibition, you file the first thing is to file the application. Don't disclose it. Don't display it, your product in any meetings. Just file the provisional application with limited disclosure, and then you can have the complete specification within 12 months. This is a just flow chart. And then this flow chart is more important. Actually, it is showing here the timeline also for each step, although that was also there, but it is showing the timeline. I'm just saying here, I just want to focus on this aspect also. Patent application filing fees. Don't think it is very cumbersome or expensive method of filing the application. Nowadays, government has taken major steps to increase the filing from the educational institutions, because a lot of research is being done in universities and colleges, but it is not protected because government has realized maybe the fee is more. So they have changed the fee recently, in a drastic manner. You see, I have just compared it here, the reduction in the fee, and educational institutions, especially, they are included in the fee reduction, these things. For major entities, this fee is 8,000 just for filing one application with limited number of 30 pages and 10 claims. And here only 1,600 educational institutions has to pay the fee to the patent office. And for each step, there is a reduction in the fee. The examination request for examination for the major entity, it is 20,000. For universities, it is 4,000 only. So there is a drastic change in the filing and granting procedure. For each step, there is a fee involved in the patent office when you are filing the application up to the grant. And up to the grant, after the grant, even maintenance is very cheap for institutions. As you natural person, startup, small entity, or eligible educational institution. Universities are coming in educational institution. So they have reduced the major reduction in the fee. You see, for major entities, they are 4,000 for 4 years. First 4 years, 4,000 per year. Here, the first 4 years, that is 800 rupees per year only. So a lot of changes are being done in the fee structure. So please do file the patent applications. As a student, if you are a researcher and you think it is a novel, you just check it, whether it is novel, inventive, and utility. Go to your IP cell and tell you want to file the application before you disclose to anyone, and then you can file it as early as possible as a provisional specification. Then you are free to publish it. And within 12 months from the date of filing the application, keep in mind 12 months time, and then complete it. Complete submission is to be done. Otherwise, your application will not be going further. So it will be abandoned. So you just file the application before you disclose it. As a researcher, I am always knowing that I was facing this problem with why researchers in CSIR. Many times they disclose it, and it is really difficult to manage that IP, because when you are taking advantage of 12 months grace period in India, And sometimes in different countries, if you have a business or licensing opportunity in other countries, there may not be the 12 months grace period. So it will be difficult difficult to file the application in that particular country. So just think it is not to be disclosed and file the application first. I think I should close. I must thank you for listening me. If you have any question, please let me know. I will be happy to answer.
Thank you, ma'am, for
Thank you, ma'am, for
enlightening us
enlightening us.
with
Thank you
such
so
an
much.
excellent talk. Now we have some queries in our chat box. The first
Yeah.
question is from Anuj. He has asked, the process between filing a patent and granting it takes a few years. Is our work protected between that interval?
I just want to tell you now it is very fast. It is not years. It used to be years before. But if you are really want to file the application and get it grant, it is within a year it can be. It now drastic change is there in the patent office granting procedure. So you file the application. At the time of filing the application, you just make a request for the early publication, and then early examination. So
Yes.
you have to spend little more money to get the fast track examination. So that is the thing I just want to tell you. But as the question says, you are protected or not. Your protection will be starting from the date of filing. But you can, when you are, if there is any damage of your IP, then you can claim from the back date.
Okay.
Understand? Yeah.
Ma'am, the next question is from Damayanti. Why different countries have different patent laws?
Because there is no harmonization of patent laws. Every country has free to have their own laws depending on their requirements. India has different law, US has different laws, and there was a lot of efforts are being done in all over the world actually to harmonize this. At present, what we are having laws now, they are almost at par with the US or any other countries. 20 years time, and before we were having very less time. So these are the efforts given by the government depending on the requirements of their own countries, because our requirement is different, their requirement is different. Accordingly, in the interest of the public, the laws are enacted, because all are different people. That is the thing.
Okay, ma'am. The next question is from Anurag. If someone has business spread across several countries, so he has to file patent in all the country, as a patent filed in one country will not be valid in other. Isn't a drawback of IPR?
No, it is not drawback. When you are having business, you have to protect your product or process in that particular country. Otherwise, what will happen? They will copy it there. So you cannot stop them, or you cannot enforce your rights. So you have to file the application. If you are having a patent, suppose you are just manufacturing that thing in that particular country, you should file the application. It is not a problem. If you are a businessman, you should not mind in filing the patent applications. You should spend that much money. It is
Yeah.
definitely a time, effort, and money is required for filing the application. Maintaining that also a different thing. Maintaining up to 20 years.
Yes,
It
ma'am.
is not a
Ma'am,
drawback. It is not a drawback. These big companies, they have all over the world. Actually, this Microsoft, Google, Amazon, these all big companies, they have half of the world is covered by these companies, or more than half of the world. So it depends on your business, how big it is. If you are a big businessman, you will not mind spending money for this protection. Yeah.
yes, ma'am. The next question is from Vishakha. Can we file same patent in different countries?
Yes, same. Yes, same. But you have to make a claim. You can keep the content of the specification almost same, but
Yes.
some countries, they require different formatting of the claims. You have to change accordingly. Otherwise, it is same. It can be filed. or you can file the application in patent cooperation treaty. That is a multi filing. If you have to do that, you can file one application, just patent cooperation treaty, PCT application we call it, and then change it accordingly during the prosecution stage. Just one application you file, because this system is um, formulated for the facilitating the patent applications in multiple countries. One application, then multiple countries.
Okay, ma'am. The last question is from Sukhman. What happens if the person who infringes my intellectual property rights is based overseas?
But if overseas, if your patent or any IP is being infringed, you can take action if you have rights in that particular country. Suppose you have filed the application or you have right only in India and somebody is infringing your property in US, you cannot stop it. You cannot stop it. But if you have in US your IP rights, exclusive rights, by filing application, application, you can take steps to enforce your rights in US. You have to take action over there. You have to hire the attorneys. You can take help from them.
Okay, okay. Thank you, ma'am, for us solving our queries. Thank you so much.
Okay, I'm very happy. Thank you so much for listening.
Ma'am, thank you for sparing your valuable time with
Thank you.
us.
Monica, ma'am, continue. Please
Thank
you
you.
continue.
Happy people. You are having already IP cell and all, because you are working under, I think, for this national IPR policy. You are following all the steps.
Yes, ma'am. This is an institutional requirement.
Yeah, it is requirement. So it is good to learn from you that Delhi University is taking action, and they are more aware about IPRs and all. So, and the students, you see, students, they are very good, and they have very much potential. All students, they must be aware about IP. Nowadays, it is essential.
Ma'am, actually, we need experts like you who have actually done work in this field. And
Yeah.
first-hand experience always helps.
Mhm.
Your experiences have brought in new insights about the process and how one can go about various aspects of IPR.
Thank you so much.
So, what is in the what is next? What is in the pipeline there?
For you are asking me?
No, no, ma'am.
No,
I'm
no, no,
asking the
ma'am.
students. So,
Ma'am,
Okay.
ma'am, I think we can thank you formally. Thank you so much for sparing your valuable time and sharing your insights. I'm sure students are more learned. That is why we had questions. When you have
Yes.
questions, you get to know that students are
Mhm.
listening to you. I must tell you that on my own, this it was really useful to attend to this talk. I am more learned on patents today, and I have some new insights on various aspects of patents. So, again, the thanks again. At a very short notice, you accepted our invitation. And I think we must also thank Innovations and Technology because you're not here in Delhi and we have been able to connect to you, and it was possible for you to share your expertise with us. Thanks a lot, ma'am. Thank you.
Thank you so much, Monica ji.
Thanks.
Thank you. And if you have any other query regarding the
Yeah,
patent
yeah.
filing
Ma'am,
and
we'll be needing your support and
sure,
expertise in future as well. Thank you.
definitely, I am always there.
Thank you.
Thank you so much.
And now we are immersed with colossal euphoria and felicity to amaze once again with our eminent prominent persona to grace this event, Dr. Rekha Chaturvedi. Ma'am is currently practicing as patent consultant and patent facilitator. She is the former MHRD IPR Chair Professor, University of Delhi. Ma'am has a great professional experience as patent consultant. She has served as the registered patent agent with Indian Patent Office. She has been a scientific advisor to the Indian Patent Office along with more than 20 years experience in intellectual property rights, IPR management, and IP protection. She has also worked for about 24 years as senior scientist with IGIB, a constituent laboratory of Council of Scientific and Industrial Research (CSIR). She has also worked as Scientist G and head IPR and PME divisions at CSIR Institute of Genomics and Integrative Biology, Delhi, and as scientific advisor to Directorate of Forensic Science, MHA, Government of India. She also has a precious research experience of over 8 years with the University of Oslo, Norway. She has published nearly 30 research articles in reputed journals and also has 3 patents. She works tirelessly to popularize and spread awareness about IPR. Ma'am, we are truly honored to have you among us. With these words, I now request Dr. Rekha to kindly deliver the lecture.
Thank you very much.
Good afternoon, Rekha ma'am. Ma'am, Dr. Gunjan Arora is going to share your screen, so I hope that is absolutely fine with you. You can.
Yes, of course.
Okay.
Yeah.
Okay. Thank you so much, ma'am.
Today I'm going to speak on a ever important topic of innovation and intellectual property rights. I thank the organizers and the Innovation Council of Hansraj College that they have given me this opportunity to present talk in front of you. I have been to Hansraj College 2-3 times previously and had a good experience and of very interested students. Now, intellectual property rights, as my previous speaker here, Dr. Indra, has given you a flavor of intellectual property rights and have made my work a bit easy. So, next slide, please. You already have got an idea that intellectual property is the product of mind which has some value to the society. They include creations, expressions, inventions, literary, artistic works, processes and products, designs, etc. Now, when we say it is product of mind, that it comes out of our intellect, and we have certain, it is the wealth of mind. Why we are calling it wealth of mind? Because when you have intellectual, registered intellectual property or protected intellectual property, then others can ask you to license to them and they can use it in return of money. So I am calling it wealth of mind. It's time to realize that this wealth is not just intangible knowledge. Now, what is intangible? Intangible is we cannot touch something, then it's called intangible. And knowledge is always intangible because it is inside our head. Now, we have to unlock this asset to develop it into products and processes which are useful and convert intangible intellectual property to tangible assets. Next, please. Next slide. First, let me tell you what innovation is. Now, innovation can be defined as application of new ideas to the products, processes, or other aspects so that they lead to the increased values. Now, that means which is already existing, if we add value to it, then it becomes innovation or innovative product. So, innovation, of course, includes the element of novelty. Next, please. So, if we have an invention, suppose we have invented a chemical product or a pharmaceutical product. Now, unless it reaches the market, it is not of any use. So what we do, and we have got a granted patent on it, then we add use various things to add value to it. That means we innovate. What we do, we may pack it into attractive packaging. We put a paste uh, name to it in a very special kind of way, and we strategic market planning and commercialize it, and so that it reaches the market. so that people will buy it and the innovator will get money. So this is what how invention can lead to innovation. Next. Now there's a difference, slight difference between invention and innovation. Coming up with something new is invention, which is useful. Coming up with a better way to use the produce or distribute the invention is innovation. So successful exploitation of new ideas in the form of useful machinery, that is devices or process by a person using his or her own intelligence is called invention. No, there's how what is innovation versus invention? Innovation and invention can be considered to be the two sides of the coin, and both are the result of creativity. So you can convert cash into ideas, and innovation can convert ideas into cash. To invent is to make something entirely new, while innovation is a practical application of new inventions into marketable products and services. And it adds values to the existing product or service. It increases the market share of a product and better way of distributing. There are many stages of the innovation process. Basic research happens first, and then you get ideas, and then you do applied research. A lot of information is generated, which can be in the form of invention, blueprints, plans. Then you do development testing, and a prototype is made, and then you need investment to go further and in the innovative way to market it. Next, please. There are many categories of IPRs, have you already heard from the first speaker, that the patents, trademarks, industrial designs, copyright, geographical indicators, and protection through of or trade secrets. So IPR regime in India is regulated through many acts and laws. Different kind of IPs have different legislation. For example, Patents Act 1970, which has been amended, and in presently we get new amendments that recently happened in 2005. The Copyright Act, as amendments have to be done in the Act to with time. Trademarks Act, Designs Act, GI Act, and Semiconductor of Integrated Circuit Act. Next, please. So why should we have separate legal framework for different kinds of IPs? Because they're intangible in nature, they're easy to copy. Difficulty to prove the ownership by possession of IP. IP laws provide the framework that how you get protection and what is protected. If you do not have control of your IP, then someone else will have. They will copy it and pirate it and make money while you have put your fruits of labor and money, and the other people are pirates are making benefit. Next. Now, as I told you, Dr. Indra also told you that IP rights can be of two types, basic categories, that is industrial and then copyright. So industrial property. Now, one thing we have to bear in mind that all kind of IPs are like any other property. If you have a property like, let us say, flat or piece of land, and you do not protect it by fence or by a lock and all that, then what will happen? Somebody else will come into your property and live happily, and you will not get anything. So that's why we have legal framework to protect, and in case some kind of infringement occurs, some pirate comes, then how to get him out, how to enforce your IP, and uh, then there are certain punishments which can be given to the such pirate. So all that is mentioned in the legal language in the different IP acts. So when we say copyright, so why don't we call it copyleft? Because it is a right, so we call it copyright. It is our right. So copyright means exclusive right to do or authorize others to do certain acts. Now, when we say exclusive rights, that means you exclude others to use your copyright. copyrighted material. So, what are those acts in relation to literary, dramatic, musical, and artistic works, cinematograph, film, sound recordings? The nature of these acts varies according to the subject matter. Basically, copyright is the right to copy, reproduce the work in which copyright subsists. So, copyright is a bundle of various monopoly rights, which includes rights to make adaptations, reproduce the work, right to issue copies to the public, and right to communicate the work to the public. So all these rights are called a bundle of rights of copyrights. So once you have a copyright, then you have a right to make adaptations. You have to reproduce the work, right to issue copies, right to make translation, right to communicate the work to public. All these are the rights that you get. And if somebody wants to use your right, they have to pay you royalty and get a license through an agreement, through a license agreement. In various terms, clauses are defined, and then they can do it. Remember one thing: when we have a copyright and you publish something, that then you enter into a agreement with the publisher, and then that is the writer and the publisher agreement. So that in agreement, you can because of that you can use about 30% of your work for educational and research purposes, and that is called fair dealing. So if you are a teacher and you have written an article or you have got a figure in the article, then you can use that figure with the permission of the publisher, because otherwise they own the copyright, basic copyright, and you have got the author's right only. So please bear this thing in mind. Next. Next, please. So copyright vests in literary works where the term of protection is life of the author plus 60 years, and artistic works like painting, drawing, sculpture, photograph, where the term of the life plus term is life of the author and 60 years. Movies, TV shows, ads, where the term of the protection is for 60 years from publication. Musical notes, tunes, there the term is for life of author plus 60 years. Songs, podcasts, the term is for 60 years from the year of publication. And plays and speeches, where the term of the life of author plus 60 years. You see, so all these kind of works, they come under copyright protection. Next, please. So there are exceptions to ownerships. It is not that you have done something while you are in employment in Delhi University or you are a student in Delhi University, then you say that it is my copyright. No, it is the employer or it is the copyright of the organization. That means Delhi University, because they are giving you all the facilities, and so that you are able to produce this work. After you have left the Delhi University and then you produce something, then it is called, you can be the owner. But you will be the author, you will not be the owner of this IP. So in case of employment, it is the employer. Employment by newspaper, magazine, employer has the publishing rights. Other rights are with the author. Photograph, painting, cinema for public sale, buyer has the right because they are paying money to use it. Work of the international organization, that means international organization have the rights. Music under contract by film producer, then the film producer has the right. But again, the performer's rights are there. They get the rights, they get a certain portion of the royalty. Lecture delivered in public, the person delivering, like I have my rights on my slides and my lecture. Government work is the government. Public undertaking work, public undertaking. Can't see the bottom. So encyclopedia dictionary is the editor for collection. So you see that who is the owner of IP? Often we get this kind of uh, uh, quarrels between the author and the organization. So one has to be very clear in these things, that who has the rights. Like you are students, then if you write a thesis, then you are the copyright. You have the copyright. But if some patents come out of that material in the thesis, then the DU is the owner if you are working in DU. Next, please. So duration of copyrights, as I have already told you, explained that what is the term. But one thing I forgot to tell you about the broadcast or the reproduction rights are there for 20 years, 25 years from the beginning of the calendar year, next following the year in which the broadcast is made. Same is the performer's right, that 25 years from the beginning of the year for the next year. Is copyright registration compulsory? No. Then why do we apply for copyright registration? Because as per the section 13 of the Copyright Act, copyright subsists in the work. The moment you make a certain work, copyright ensues, you get the rights. If a child is scribbling something on a paper, it is his or her copyright. So you see that automatically it is your copyright, but you need a registration certificate only to act as evidence and makes it easier to prove that you are the owner of the work. Because often this kind of problem come, the conflicts come, that somebody has written a book, and then we get this kind of questions or the complaints that so and so has copied so all these works. So how will you prove? First thing is when your work was published. Second, if you have a copyright certificate, then it is easy to punish the culprit. Next, please. So registration certificate makes it easy to prove that you are the copyright, you have the copyright of the work. Next. Next slide. Next slide, please. So there is one the design can be is another kind of intellectual property is design. So we have to enter for the design registration with the design office, which is in Kolkata. The design can be protected by design registration, and if India in this the term of the protection is for 10 years, which can be further renewed for 5 years. Design should be, what the condition is, design should be new and original with no prior disclosure. So when you have a design, you have to do searches in the patent office, design offices. There's a design database that if you are copying somebody's design or how much somebody's design resembles yours. So minor modifications will not help. It should be new and original. And if you have disclosed this somewhere, then it cannot be protected. So it has to be significantly different from your design or combination of design. It can be applied to the article. For example, if you made a painting, that small painting is very attractive and it can be you put on a crockery, it can be put on a card, it can be used differently in different kind of products. But the design remains the same, and you have a you will get a part of the royalty when it is commercialized. Next, please. Some examples are here. For example, paperweight, cufflinks. See the unique design. It is a paperweight, but it has a clock. So it has kind of, it is not a paperweight. It is a kind of cricket ball having this. So, but it doesn't have a function of ball, but can be used as paperweight. See the design of cufflinks. Now, yeah, we see in the next slide, we see how the design of the Coca-Cola bottle has changed over the time. So in 1899 to 902, it was like this. And then this design came, and this design, see, they're totally different. And now presently we have this design, Coca-Cola bottle. It is on the plastic, and the designs can evolve with time. If a product which is long-lasting product, if you put an old design, then it is not of very great use. So with time, the designs of the same product can change, but they have to be registered separately. Next, please. And then we come to the another uh, kind of intellectual property, that is DI. GI is the geographical indication of goods. It is a sign which is used on the goods that have a specific geographical origin and possess qualities of a reputation due to place of origin. Registration of GI is for 10 years and is renewable. Now, when I am saying place of origin, then what does it mean? For example, basmati rice. Now, basmati rice is a very special kind of quality of rice which has been developed in the Tarai regions of Dehradun. So people call it Dehraduni rice also. It has a special kind of fragrance and the grains are long. Certain qualities are there. But if you grow a rice variety in Delhi and you sell it as basmati rice, then it is wrong. It is punishable by law. Unless it is from Dehradun, you cannot sell it as, because it has a specific geographical origin and it has qualities of reputation due to that place of origin. So there are many such products which have been registered under GI. Excuse me. If somebody does the piracy, then there is a imprisonment of term between 6 months to 3 years and a fine between 50,000 rupees to 2 lakhs. A very interesting case is there where I'll discuss that case later. There are some examples of GIs. Next, please. For example, Naga Mirch and Kullu Shawl and all these you can see here. This they are all from different places. They have different origins, place of origins, and they have got their specific qualities, and they all have GI registration signed with them. Next, please. Another example is Lipton Green Label, that is finest Darjeeling tea. That is what you have to note, Darjeeling tea. This is another brand noted, but it is Darjeeling tea. So why we call this Darjeeling tea? You to local tea, you cannot give the name Darjeeling. Darjeeling tea has specific kind of fragrance and special qualities, so that it is called Darjeeling tea. Next. Another one more is the plant varieties rights. This act is there. So Indian Act is rather unique, where the plant variety protection is done and we protect the farmers' rights, because farmers are the people who have done a lot of work in breeding to get new good qualities of new plant varieties. It facilitates the growth of the seed industry and ensures the availability of high quality seeds and plants and material to farmers. Next, please. There are many registrable plant varieties, but there is important is the new varieties which is not in public domain in India earlier than 1 year before the date of filing. And extant varieties are there which is notified under Seed Act. So when they register the plant variety under this act, then they get certain protection, and that protection is very useful so that the farmers cannot be exploited by big seed companies, and to prevent the fights between the seed companies. Next, please. Next slide. Next slide, please.
Ma'am, I've changed the slide maybe because of the internet
Slide.
connection going slow. Uh,
Mhm. So can you yeah.
Yeah, I think it's there now, ma'am.
Yeah, yeah. Then another kind of IP is trademark, which is very important. And you must have heard about trademark. Dr. Indra also gave an introduction to you. Now, trademark can be a word, symbol, logo, slogan, or any combination thereof that is used to identify and distinguish one person's goods or services from the goods and services of another. And it serves an indicator of source of the goods and services. So when you have the trademark, which are unique, each company has their different trademarks for a particular class of product. Then when they apply from trademark, then they can say put a word TM in the upper scripts and SM if it is service, and this R with circle notation with trademark when it is registered. They get a certificate of trademark registration. Then it is R. So you can immediately recognize whether they've applied for TM or SM or they are already registered. It's merely so that the person claims trademark rights to the work, slogan or phrase associated with TM or SM. The same can be used once the grant of this thing is there, after the uh, grant of the symbol R is used. But without that certificate, one cannot use this R. Next, please. So, as all IPs have different kind of acts regulated through different kind of acts, Trademark Act is also there, which defines that trademark means a mark capable of being represented graphically and which is capable of distinguishing the goods and services from one person to those of other and include shape of goods, packaging, and combination of colors. So this definition is very clear. When they say combination of color, like we come to this trademark of BMW. So it has to have this kind of circle, BMW written like this, and this blue and white here. So it cannot be green and yellow or any kind of thing will not indicate BMW. BMW has to have this kind of thing, which is the registered trademark. Same is with the Apple. This cut cannot be on the left side. It has to be there only. Then it is represents the apple. Like Amazon, McDonald's, they have special kind of M written with this color. You can't have another color other than the registered this thing. Otherwise, it will be misuse of the trademark. See how Toyota is written, LG, then Siemens. So all these are different kind of trademark symbols and phrases written in a different way. It helps in advertising because it indicates the quality of the goods. Once anybody comes to know that your intellectual property is protected, then they immediately get the ideas. It must be very useful. It must be following the law of the land, and that's why they have been granted this certificate. And it creates the brand loyalty. It is a very important commercial asset, especially for the big companies and uh, startups, MSME, all these people who are thriving on the various kind of products. And this has to be very innovative way of doing it. So you see the innovation have come here also, and they give exclusive rights to the owner of the trademark which can be enforced. So enforcement means if somebody is pirating or they find that somebody has pirated, then they can complain to the police and get punishment or a fine. Next, please. Other examples are here. See, this is R. This kind of R they can put on the product with trademark, which is called, this is a registered trademark. And TM on the product, if you write this, that means you have applied for. So other examples are there. Kellogg's 007, immediately you think of James Bond. And Wheel soap. All these are everyday life things which we are surrounded from morning till evening. When unless all kind of different kinds of words, letters, numerals, slogans, characters, and shape of goods are there. Packaging, very special kind of packaging, combination of specific colors. Then there are sound marks also, smell marks also there, which is to the fragrances. And the name is written in certain style like this, you see, Taylor Swift. And invented fanciful words, they combine the they include the trademark. Sometimes, like you can see, they write wrong spellings. So they now knowingly put the wrong spellings so that immediately the person, the customers is attracted towards them and will see what it is. So you see, TM helps in advertising. Next, please. Next slide. Next slide, please.
I have changed.
Any
Ma'am, I
problem?
think your net, there's some problem in your net because we can see the slides are changing.
Oh, so net is there. You can go to that, yes. There are creative trademarks also, which indicate the property of the trademark. For example, freedom, a word bird is flying away. Then freedom 55 financial, you see flying bird. Then vino piano is a kind of wine where the vino is from that wine and piano come the keys of the piano. So this is orange cat, so orange and kind of cat. It's not cat. So you see, these are creative trademarks. Next, please.
Ma'am, she has changed.
So all this I have already explained. What is TF, SM, and R? Next, there are many types of trademark for registration. The product trademarks are affixed to identify goods. Then there are service trademarks, identify the services of an entity. For example, trademark for a broadcasting service, retail outlet, etc. They can be used in for advertising. Then there are certification trademarks, which are capable of distinguish the goods or services and are certified by the proprietor with regard to origin, material, and method of manufacture, and other qualities. Then there are collective trademarks, which are registered in the name of groups, associations, or other organization for the use of the members of the group in their commercial activities to indicate their membership of the group. Next. Next, please.
I have changed.
Just a minute, I will check the internet. Listen. सुनो इंटरनेट चल रहा है ना हाँ it is on. Can you please change the slide? प्रॉब्लम आ रही है.
Is it visible now?
Yeah, please change.
I have already changed.
Ma'am, right now you can see what on your screen. Why trademark registration? Can you see it? Okay. So, Gunjan,
नहीं, types of trademark for registration. After that, I cannot see.
can you see it right now? Why trademark registration?
No.
Ma'am, it's coming on the screen.
Okay, let me share my screen again.
Okay, just.
Is it visible now?
Yes. So, but why should we do trademark registration? Why can't we just make a trademark and paste it on our product and sell it? Because it has. If we don't do trademark registration, then you see simple thing somebody can copy, and that trademark registration certificate is the only thing that can prove that it is your trademark. It protects your hard-earned goodwill in the business. that this is a quality product which has been used for years, and because it is indicated by the trademark, it gives a brand name. If your product is a gives a it gives a status of branded goods to your product. So if it is branded, everybody prefers. If there is Levi written on the jeans, then everybody wants to buy. But if it is no thing, they say, oh, it is a local thing, why should we buy this? So you see, the value of the good diminishes if you don't have a uh, brand or a trademark. It, the it gives that impression that the company is selling some standard products, and the exclusive right to use of trademark in relation to goods or services, it excludes others to use your trademark. And you can get relief in respect to infringement, because if it is misused, then there are in the trademark law, it is written about the punishment in the form of fine and imprisonment, or both. Next, please. So you see, when I just said misuse of trademarks, then you see here MRF Sigma. Now, MRF is a tire. So if somebody is selling with MRF of Sigma or Nirma as Nirma Tiger Tea, it is not possible. So it gives a wrong impression. It fools the customers, and they bite into the economic share of the market share of the owner of the real trademark. Then you see some identical trademark in respect to different classes of goods. Like Benz for inner wear is very strange. Caltex for watches is very strange. And Kodak for cycles is very strange, because all these are there for a specific class of goods. Like Kodak is for a well-known brand of camera. Now, use of deceptively similar are also very difficult. So, for example, TGIRF, Evokia. So Nokia का Evokia बना दिया. So this is very, I mean, these are the misuse of the trademark. I'll give you a very interesting example of this. That these hearts which are put on the road, this Sunday Bazaar and Monday Bazaar. So once I was passing through, then I saw that there is a toothpaste called, in the spellings are Colgate. It's written in the same manner as Coagulate, it was written, and the same manner how Colgate is written. So you see, it's the same kind of tube, same kind of colors they had used. So you see, it is misuse of trademark. It fools the customers, and they mistakenly buy the product, and then the original trademark product cannot be bought by them. They get an inferior quality of goods. Next, please. So similarly, Pepsi Cola trademark has evolved over the time, you see. Like now it is this. So it immediately indicates that it is Pepsi Cola. Next. Now another kind of IP is trade secret. So trade secret is a secret information owned or developed by a business that gives it a competitive advantage. There are many people who don't want to file for IP. They want to protect their IP by trade secret, because they think that they have to disclose information if they have to file for the IP, and they don't want to do it. They protect their IP by contract law. They have contracts with their employees and their co-workers and their collaborators, so that it cannot be uh, misused. Then there are famous trade secrets like KFC, where nobody knows what kind of spice they use, what spice mix is there. See, Listerine, this is the formulation nobody knows. And the famous case is Coca-Cola, where the entire content of this Coca-Cola is known only to two persons, and nobody knows what is the real formulation, so that nobody can copy it. So, but there is a danger in this trade secret. One can do trade secret licensing also. For example, this Listerine. Next, please. Now, knowledge which is continuously developed, like traditional knowledge, acquired, used, practiced, transmitted, and sustained by the communities, or given by handed over from generation to generation. So it is called TK, that is traditional knowledge. It includes existing oral knowledge which cannot be protected through under the provisions of existing IP laws. So, however, there is a substantial improvement in the existing traditional laws. It can fulfill the requirements of the definition of invention, that it should be there in the public domain. So what happens here? Like this example which was given to you by Dr. Indra, that CSIR has done a lot of work in it. They have developed a digital library called TKDL, Traditional Knowledge Digital Library, where uh, many Vedacharyas, after this turmeric case, many Vedacharyas, doctors, Siddha and Unani experts, they were given this task, and they found out what different kind of traditional knowledge, and they digitized the knowledge. So you see then what happens, that the patent offices have access, different patent offices have access to this traditional knowledge databases, and they can find out whether it was already there, so that we don't get this turmeric and basmati kind of problems. Basmati rice also was having the same kind of thing. Then there is an NGO which is run by Dr. Vandana Shiva. She fought for it, and then this there was protected. Next, please. Now we come to another very important IP, that is called patents. Now patents is a very glamorous word these days. Everybody wants to file patents, but they should first know what patents are, what is their importance, and how to file a patent, which has been a bit explained by Dr. Indra very well in her lecture. So I will also attempt to, let us say, repeat the whole thing. So important, they are important source of scientific and technical literature. Once you have your patent document, and in the patent offices they have databases where different in patents are there, they have the whole specifications there. One can read those and find out about the particular product, because then it avoids duplication. We do not have to reinvent the wheel, and identifies emerging technologies and areas, so you can find out that where you are interested in, what is the life cycle of that particular technology, whether it is still in this way, or it is after the peak it is coming down. So this is what one can always see if you have a technology profiling of the various for a particular technology in a database. Thank you. And then next slide. So that's why patents lead to technological advancement. It is perceived as a technological advancement, and it as an incentive. So it, because it grants the owner the right to exclude others from making, using, selling, offering to sell, or importing into the country the patented invention. So award of a patent is indeed intended to stimulate the investment to develop an idea and bring it to the marketplace, which are embodied in the product or processes. So if you have a get a award of a patent in return of your disclosure of the invention, then you have a incentive that you have got a patent right, and nobody else can copy. You have excluded others from using it without payment of royalty or license. Next. So, as already you know that the patentability criteria are there, that it should not have been published in India or elsewhere. What I mean is, many times the students, or they think it has not been done in India. So they will say it is not done in India. No, that is wrong. It should not be published in India anywhere. There should not be prior public knowledge in prior public use anywhere. And claimed before any specification. So if you have got, somebody has used it or exhibited it, or you have by mistakenly presented somewhere, then it cannot be patented. So always consider this: first patent and then publish. Or as very famous slogans of Dr. Mashalkar is there, PPP, that is publish, and perish. So it should be an opposite, that you should first patent and then publish if you think it is patentable. Now, very important thing is whether it is patentable or not, because every invention may not be patentable. Next, unless it is completely novel. So, see, many ideas can be converted into inventions. This is how the inventions occur, that you've got a certain idea in your mind and you want to develop into a product. For example, this fellow, Frank Epperson, saw that this ice is getting freezing in the cold. So he developed an idea to develop popsicle, that is the ice lolly. See, we still eat ice lollies. Everybody likes it. And then this penicillin, it was the first antibiotic which was accidentally discovered by Alexander Fleming. And it was later developed by Florey and Chain in Oxford University. So what happened that in his lab, in the lab of Alexander Fleming, many kind of microbiological things were developed. And there, once they left the petri dish outside, and they saw many circles of things are appearing, which are not all over the petri dish, means something is preventing. There is a circle around its growth. So they further examined it. They found that it has got a antibiotic property, that is kills the living things or the bacteria. So they further, this gave them the idea how to it can be developed into a antibiotic compound, so which will be anti-infective, which will kill the infections. So many other have been developed things by this. Another example, very well known example, is Velcro. A Swiss engineer, this Georges de Mestral, he was on a hunting trip, and he discovered that some birds, the seeds having spines, were sticking to his dog's fur. So he thought, then he further examined it, and he saw that it can be developed into something to uh, put together without a zip. For example, this Velcro. So this is the large picture of Velcro, where you see how the Velcro hooks are there. And this very important, we have it on the shoes, we have it in many things, so that we have can bind two things together without a zip. Next, these are also patented inventions. Bulb, this flip top opener, many kinds of these openers are available now. Each cost only 1 cent, but you see how many are in use all worldwide in different products. So it's a lot of, it make the owner a billionaire. Safety pin, we are every day using safety pin. Pen, U pin, so such a simple thing. And U pin is holding papers together without punching them. And the needle of a machine, this is the another thing. So all these are invented things, so which have been developed from the ideas. Next. So now, what is meant by a patent? So patent is an exclusive right granted by the government of a country to make, use, manufacture, and market. And nobody else can uh, import without the, or manufacture it or use it or market it without the permission or of the owner, because it is exclusive right. It excludes other to use your invention. Next, if the patent is for a process, then it confers the rights on the patentee to prevent others from the act of using the process, using the product directly obtained from the process, offering the product for sale, and selling the product directly obtained, or restricts the importation by anyone else other than the owner. Next. So as already I have explained this, that patent information is important source of researchers and investors, entrepreneurs, and commercial enterprises, because it has two important functions. One is protection, which allows the patent holder to exclude others. And second thing is disclosure, because when you give a full disclosure that how you have made it and how it is advanced from the existing prior art, then you get a award of a patent certificate. Next. Now, what is patentable? Product process patents in respect to novel compositions, drugs, chemicals, agrochemicals, food and microorganisms. All these are patentable provided they follow the three cardinal principles of patenting. That is, they are absolutely novel, has not been found anywhere, has not been used anywhere, has not been sold anywhere, which is having an inventive step, is not obvious to a person skilled in the art, and has a industrial utility, potential for industrial utility. Next, please. As I already said, now what is invention? It means a new product or process involving an inventive step and capable of industrial application. You see, then this thing covers the definition of a patentable invention. Inventive step means a feature that makes the invention not obvious to a person skilled in the art. For a chemical invention, it is the chemist who is the person skilled in the art. It is capable of industrial application. In relation to invention means that inventions are capable of being used by the industry. If it is a pharmaceutical product, then it could be used by the medical industries and so on. Next, then there are software inventions also, and it is slightly different. The software inventions are very special kind of inventions, where the claims for solving the technical problem by a computer-based method may be patentable, provided steps are clearly defined. The mode of implementation is given through the software. Embedded hardware should be clearly defined. So unless these things are there, algorithms per se cannot be patented. Next, algorithm have to be patented through copyrights. You see, there is a combination of different IP protections which can protect the software protection, give the software protection. Patent, method of implementation, and software, then trade secret. You can keep certain information very secret. So this is how a combination of three kind of IP protections can protect the software protection. Next. I'll giving the slide the same kind of this single product having multiple IPs, as Dr. Indra gave of Coca-Cola bottle. So contents inside are the subject matter of patents. Temper seal is the subject matter of patents. Brand name, logo, subject matter of trademarks. And external appearance, subject matter of designs. Here you see this has got a different design. The Bisleri bottle has a different design, has a different color combination of the trademark. Like there are other examples also, like Finlay. So they are immediately it is Finlay. So these are the branded products. If you're traveling somewhere, will you buy a bottle without any kind of brand or anything that you do not know? So you have to have a IP protected sub, thing which has got a brand name, then only you will use that product. Next. So what we have to do, that we don't have to duplicate research, so that time is not wasted, money is not wasted. We have to determine the patentability for their inventions. We have to avoid mistakenly, people uh, mistakenly people copy somebody else's IP. So this is very often done, can be a mistake for the new entrants in the commercial arena. That is like startups, like MSMEs. So because if they do not have a knowledge of IP, unknowingly they can infringe. Sometimes what happens, somebody uses a software, okay, which is available in the public domain, and then they make develop certain things and want to file a patent or a copyright or anything, but then mind it, because it is based on somebody else's software which is IP protected, then you cannot do it, or you have to take permission from the software developer. So you have to estimate the value of their or other inventors patents. You have to exploit the technology from patent applications that have never been granted. You see, this is another use of the patent databases, the patent applications which are in the databases which could not be granted, which are not valid in certain countries, then you enter those countries. So these are all patent strategies which that or patents which are no longer in force, but mind it, it has to be still different, very much different, so that you don't get this problem of invalidation due to prior art. You have, if you can gain intelligence if possible for the innovative activities and future directions of business competitors, like as sometimes it is given in their board meetings, but board meetings, their minutes are secret. You can improve planning for business decisions such as licensing. You have to identify the key trends, what is happening, and you have to plan for business decisions such as licensing or collaborations or partnerships and acquisition. These are also there in this commercial world. Next, so patent grant procedure, there are many patenting actions, from start to end. So first you file a patent application. Now, if it is a patentable thing, first thing you have to do is a patentability assessment. You have to do a thorough search of the patent literature and the non-patent literature, I mean the articles which are published, and then see if the compound of the subject of your interest is mentioned there. What is mentioned? So if you find that you have got a freedom to operate, then and it is you patentability assessment, there are certain drawbacks in those patent applications or written methods which is explained in the non-patent literature. Then you can think how to avoid uh, those drawbacks, and you can think of a new idea that how to avoid the drawback and then file a patent application. So patent application has to be written in a particular format based on the Patent Act. It is a very specialized work. And then once you file the patent application, then it can be published after 18 months. You can also apply for a earlier publication after payments of certain fees. So payment of this filing of this patent application is of two types, mainly two types, or let us say four types. One is a provisional application, where you just give the proof of concept. You don't explain everything, various aspects you give, because you are in a hurry and you have to go and present somewhere, or you have to have a board decision or something. So then you go for provisional filing. And then after 12 months, you can go for complete patent application filing. The deadline is 12 months, which can be extended by post dating. There are certain procedures which are involved based on you have to file pay some money, and then you can post date, and then after that you can do. And there is a patent of addition. If you have got any additional work done, improvement, then you can file it under patent of addition. And then there is divisional application, because suppose you have filed process as well and product, both are there in the claims are there in the patent application. Then the examiner may say, please divide into two, file process patent separately and file product patent separately. Then it will be divisional patent. So both the applications, only complete applications are published after 18 months. You cannot publish, they don't publish the provisional applications. Then there is request for examination after you have to file. You get 4 years to file for request of examination. But it is better the moment you file complete application, you can apply for request for publication, early publication, and request for examination. The request of examination can be of two types. One is through the normal method, and then another is the expedited. So with request of examination, your application gets into the queue for examination. And based on the workload on the patent office, they do the examination. But they do, and then a first examination report is issued, and then you have to, where there are certain objections are there or not, and then you have to give the response to the first examination report. And if the examiner accepts, then you get acceptance, or you have to give another, you get second or third examination reports or hearing, and then it will be either acceptance or refusal. It all depends on your application, whether it is absolutely novel, whether it is mm, has an inventive step, and whether it has got an industrial application. So then you get a notification of acceptance in the Gazette of India, and after opposition to grant some time, after uh, time is given if somebody else is opposing it, because after publication they get these ideas how to oppose. Then after that it is granted. You get a certificate from the patent office, and your protection starts from the filing of the patent application. When we are filing provisional and then after that we file complete, then you get the priority from the date of filing of provisional application. Next. So nobody can stand alone in this world. Either you have to collaborate, especially big companies. They are all small companies like uh, uh, MSMEs and startups, especially, they have collaborations among themselves or from academia. Also, they can collaborate. They can collaborate so that they come to a fruitful result. Now, academia like universities are developing, having these days a lot of research work. They have got their IPR cells also based on the IPR policy, which was released in 2016, and lot of efforts are being made by in the academia world also. And if they have got certain technology developed, they have developed there, which is useful for the industry, then industry can collaborate with academia, or academia can collaborate with industry so that it can be further taken to the market. Academia alone cannot take it to the market because it is not their specialty. It is the industry which will take it to the market by innovation. So you collaborate like this, or industry collaboration. Two industries can collaborate. So when they collaborate, then a particular collaborative agreement has to be written where all the terms are very clearly mentioned. Either the industry will license the academia's license, or similarly one industry will license, or they will co-develop. They will put their efforts and money together to develop the product, marketable product, mind it. So, or academia can just do the research and industry will sponsor, that is sponsored research. So all, there are many ways to do it. So academic institutions, but there are problems. Industry sponsor the research, but not an active research partner many a times. And academia can be, it may not be, don't pay attention to the what the industry requires, and they pursue their own research, which is a wrong thing. They should see what is the need of the hour, what is technology is required, and then work accordingly. Next, please. So when you start a out commercial unit, then you have to think what product to develop. You have to do a market assessment of that product. You have to do the due diligence of the patented technology, that can it be opposed. Most important thing is opposition, because there is pre-grant opposition also and post-grant opposition also. So one has to be very careful whether it is in force or not, the patent is in force or not, because you have to pay maintenance fees every year to keep it in force. Sometimes by mistake the date escapes, or sometimes they don't want to further go for the thing because it is very expensive. So one has to be sure. Then it has to have a non-fringing clear title. That means it is not infringing anybody's product patent. So because what happens if somebody is using a technology which is infringing somebody's patent, then both the parties will get into trouble. And you have to see whether it is safe, safety issues are there. Has it been cleared of the regulatory issues? Whether it is profitable, and what is the market demand and size of market. You should have a business plan before you enter into a technology market. It should be, it should be feasible to be manufactured. What is the competition analysis? What are others? If you, or what is the freedom to operate in the market? So all these things are very important before you enter into a business decision. Next, please. There is a lot of gap which is existing to take an invention to the market between academia and industries. As I told you, the academics are inventive. They can very easily guess what are the drawbacks of a particular technology, and they can find ways to uh, remove those drawbacks, because that is what we have to mention in the patent document, that what are the drawbacks and how to remove them. Then only it can becomes a new thing. See, big rocket science is not required for filing patents. If you are a chemist and you have a compound which is produced through many steps, and where the such expensive chemicals are used, or where non-environment friendly chemicals are used, which is dangerous, then what you can do, you can think how to develop a single pot uh, method, how to which is inventive, as well as giving a higher yield. So this way your product will be, your process or the product coming out such a process will be better, and it is high yielding process, and you have it is a it is not giving damage to the environment, and it is safe, comparatively safe. So it is innovative. So we have to think all these things. There's a big gap which exists between industry and academia because of this. Because academics pay scant attention to the needs of the industry. If you want to collaborate with industry, you have to have a meeting first to find out what they require. Or sometimes industry also comes to academics that let us have a collaborative project, because we want to develop these. They find out who are the experts in which university, and they approach them. Now, sometimes what happens that industry does not have full faith in academia, because if their product will be market worthy, because it can take longer also. In academia, sometimes what happens, that lots of red tapeism is there, officialdom, this clearance, that clearance, and it takes a very long time, and then by that the industry runs away. So because R&D for the technology development is long process, and returns are possible only after a certain time, because then industry doesn't have that much patience. So we have to remove these roadblock blocks if we want to collaborate with the industry. Next. Yeah, thank you very much. Now this is the end of my presentation, because there are certain things which Dr. Indra has already mentioned, so I did not mention them so much to avoid duplication. So if there are any questions, you can please ask me.
Thank you so much, ma'am, for your precious words. Your experience and discussion have imprinted an indelible mark in our minds. So we have received some of the questions from the participants to ask.
Yes.
The very first question is, if anyone is pirating films, but he doesn't know about copyright issues, then he will be punished or not?
Yes, he will be punished. He can be fined. He can be jailed also. This
Okay, ma'am.
kind of things exist in the copyright law.
And ma'am, the next question is, where can I find papers or theses on business models based on licensing of intellectual property brands?
See, I don't know if there are any such papers that are existing, but they would be there, because a lot of work has been done in licensing. Some people in IP do research on licensing only. You have to look for it in the databases, especially the business journals.
Okay, ma'am. And ma'am, the next question is, how can the value of intellectual property become a subject of mortgage transaction in an emerging economy?
Yeah, it can be done, but for that we have to first evaluate the IP, that how much money uh, it costs. So it depends on there are many methods. Either first thing is that how much money has been spent in development of the technology, and then what is the market share, and how much money that particular patented product will earn if it enters the market in comparison to what are existing similar products. This is very important. And what is the market share, and then what kind of special properties the technology possessive. Like these days in COVID vaccines and COVID drugs, lot of research has been going on, and has been from the Indian government that they should be free of IPR, so that everybody can afford such, because patent, we are having a patented product, then certainly the cost goes slightly up. So there are various kind of things which we have to be considered while evaluating a patent or a IP.
Okay, ma'am. And ma'am, the next question is, can the double-blind reviews received on the initial submission of a journal article be challenged? If yes, on what grounds?
Pardon, I didn't understand the question. Can you repeat?
Yes, ma'am. Ma'am, the question is, can the double-blind reviews received on the initial submission of a journal article be challenged?
No, a journal article, whether it will be challenged or not, it depends on the editor of that journal. But especially if you have got a mentioned in the journal and you want to file a patent, then it will not be allowed, because it will become prior art or existing knowledge.
Okay, ma'am. And ma'am, the last question is, can we use Wikipedia images without copyright? And if not, then how can we take copyright permissions?
You have Wikipedia images are definitely copyrighted. The copyright is of the uh, person who made them or owns them, because the moment you do the make the figure, the copyright starts. So you have to take permission from Wikipedia that we want to use it here. If you want to publish it in some article, any
Okay.
image, whether it is your own article, you have to approach the uh, publisher.
And ma'am, one more question I have received, and the question is, what is the best way to protect literary work posted online for students to study?
Best way is copywriting. Even when you are writing a report, if you just write all rights reserved on the first page, whether below the title, so that will mean they will be careful. They will not copy. So remember to put all rights reserved on
Okay,
that
ma'am.
first page.
Thank you so much, ma'am, for answering all the questions. So now,
Welcome.
before formally concluding the session, I would like to request all the participants to kindly fill up the feedback form, which have been posted in the WhatsApp group. And now I would like to call Monica ma'am. I would like to request Dr. Gunjan Arora ma'am, coordinator of the session, to present formal vote of thanks.
Thank you. It's my privilege to propose vote of thanks. I would like to begin this with a popular quote. When we express our gratitude, we must not forget that the highest appreciation is not to simply utter words, but to live by them. On this note, I would like to acknowledge my sincere gratitude to our speaker, Dr. Rekha Chaturvedi and Dr. Indra Dwivedi, who took the time out of their busy schedules and sharing us with their pearls of wisdom and knowledge. We are truly humbled by your presence, ma'am. Thank you once again. We are deeply grateful to our most valued Principal Ma'am and Professor Rama and Vice Principal Ma'am Miss Alka Kakkar, who always supports us in every possible aspect. We are also thankful to Archana Ma'am and Monica Ma'am for gracing this event and providing their valuable guidance throughout. Above and beyond, let's not forget the backbone of the event, our entire organizing team, Parul Ma'am, Sunita Ma'am, and our dear students Pragati, Sukmanpreet, Vanshika, Uma, and Kartike. Thank you so much for all the hard work and efforts. You guys really made it possible. Thank you so much. Furthermore, let's have a special recognition to all the audience for joining us today. I hope that you all have enjoyed the session and gained valuable information. Thank you. Have a wonderful day.
Thanks.